Professor Fukuyama mentioned yesterday that there are as many definitions of rule of law as there are legal scholars. I'm going to spare you my definitional lecture. That would take up more time than we've been allotted for this entire panel. However, I want to make a couple of points. I see rule of law as a historical process. And so in some ways, Professor Fukuyama takes a political scientist's view that rule of law is a constraint on power, and that's its main function. But in fact, courts, 80% of what they do is not constraining power. They're deciding property cases, family matters, small property disputes, and the like, the sort of things that allow people to get on with their daily lives. So I don't think that rule of law is like pregnancy. You don't either have it or not. And even in China, I would argue that capital punishment, the rules surrounding capital punishment have been changing over the years. 20 years ago, China put forth a corporate law that has, or less than 20 years ago, has fundamentally changed the way business contracts are drafted in China. Now, China does the judiciary constrain the ultimate power of the Communist Party? Absolutely not. But there are other things going on in rule of law. I'm sure that the topic of judicial independence will come up on this panel, and I just want to tee up, I think it doesn't make sense talking about judicial independence without also talking about judicial accountability. I think they're two sides of the same coin. And then finally, a point on empirical data. Some years ago, I wrote a book, Beyond Common Knowledge, Empirical Approaches to the Rule of Law. And I wrote it because I think that data on judiciaries, as I saw around the world, and I'm not actually referring here to Georgia at all, I saw manipulation of backlog data for all sorts of reasons, and I'm much less interested in the backlog than what in the system caused the backlog to get there. So I hope that when we talk about statistics today, that we take a very critical approach to that. So without further ado, I'd like to introduce the panelists, distinguished panelists for today. The Minister of Justice of Georgia, Ms. T. Tsulukiani, not bad. This is the real test for Professor Fukuyama and me, is to make it through the introductions. Then Mr. Giorgi, Gogia, the Human Rights Watch senior researcher. I'm now showing that I perhaps should take the strategy that Professor Fukuyama took this morning. And then Mr. Kakha, Kozhoridze. Okay, this is a humiliating sort of exercise. Chairman of the Georgian Young Lawyers Association. And
I give you right to misspell my name. It's very difficult. So.
And finally, Mr. Irakli Porchkhidze. Pretty close, the closest and the last, huh? The Vice President of the Georgian Institute of Strategic Studies.
Thank you. Thank you. It's a great honor for me to be here with you today, with such distinguished guests, and I would straight away tell you that I do believe that creating and building Georgian democracy, at least it's how I do feel it. It's quite heavy pregnancy. I even have sometimes impression that one day, with very hard work, we'll give birth to a big elephant, which will be called Georgian democracy, transparent state and institutional democracy. This is what on what we work. To put it in Mr. Fukuyama's words, state building and democratization is a matter that tops the agenda of the worldwide liberal revolution. And I'm glad to welcome the Stanford Fellows present here and faculty for discussing it here with my colleagues from the government and myself. While we continue the global debate on the modalities of a modern state, of a modern democratic state, we have to acknowledge that there is no one recipe and there is no one-size-fits-all recipe. Especially in democracies like Georgia, which is a democracy still in transition. But we do stand in Georgia as a good example in doing so. In his yesterday presentation, Mr. Francis Fukuyama named the rule of law and accountability as two crucial elements for the modern democratic states. The bottom line is that the modern state and modern democracy implies building a state on inclusive political and economic institutions that ensure the rule of law and human rights protection on a systemic level. This is the key word. My personal but also political aspiration to that end is precisely what forced me to one day, 2 years ago, to resign from my permanent position of an international civil servant and human rights lawyer with the European Court of Human Rights after 1 decade of work there, and to undertake this responsibility as a member of an opposition party in 2010 and now as a Minister of Justice of this country. Of course, along with my fellow political party members and my colleagues in the new government today, for advancing the realization of this aspiration after a lengthy and unequal political battle. And the battle was unequal. It was a time where it was difficult to have a nexus to political participation, which is not the case today. A very brief overview before answering your questions, which can be, of course, asked very, very freely. Transparency is one of the keywords of this government, and I would even add another word, genuine transparency. Not a transparency which can be sold outside the country because it's seen as such. It's not a facade. I'm speaking here about genuine transparency. And I will take this opportunity to congratulate every and each Georgian present here because several days ago, Georgia was elected as a member of the steering committee of Open Government Partnership with 5 or 6 other countries. And this is a partnership in which the former government decided to participate. And this is one of the positive things I decided to continue. I didn't continue many other things, but I do continue 2 or 3 good things which were initiated before. And this culminated in the election of Georgia after 2 years of hard work. In August this year, in our election in the steering committee. Human rights strategy. You may all know that Georgian government initiated and elaborated this in April this year, human rights strategy and action plan. It was approved by Parliament, in which people's representatives sit. And it's not a 5-year strategy or a 4-year strategy. It's 7-year strategy. So it does not fit to the election mandate of a government, of a parliament, but it's a 7-year strategy which should fit to this government and also to the next government, which will be elected in 2016 as well. It was a very inclusive process with participation of NGOs, civil society, experts, and we have been also, of course, helped by Mr. Thomas Hammerberg, who was EU Special Advisor on Legal Reform and Human Rights in Georgia, sent by the EU as an advisor to our government. We created an interagency commission chaired by the Prime Minister of Georgia in order to supervise the implementation of this action plan for protection of human rights, because as a human rights lawyer who examined hundreds of cases brought by my fellow Georgian citizens against the state of Georgia during 9 years of reign of the former government, I do know that the former government was defeated in election in 2012 because of massive violation of human rights. Human rights, when they are protected, I think this is the best protection for the statehood of any country. Anti-discrimination law. This was the very painful reform, but very important. The Ministry of Justice led this year, and it ended in adoption in Parliament with some difficulties, but still with an unanimous vote of adoption of a new law. We would fight in Georgia with this law and with the Ombudsman of Georgia, who is the supervisor body according to that law, fight every kind of discrimination, direct, indirect, and multiple discrimination as well. Institutional reforms. I mentioned in the beginning that for me and for this government, it's not about personalities. We fought with the former government, and I'm very proud of my personal and my political parties and our political coalition's huge victory 2 years ago. But we fought that government, because the whole Georgia and the then government depended on personalities. I do not think that a modern state should depend on personalities. We do need in Georgia institutional democracy, which will be impossible to undo by any next government. So during my everyday work, I do have this impression to work for a next Minister of Justice, not just for myself or for this government. So institutional reforms, the prosecutor's office, the first thing we did for the rule of law was that I abandoned my prosecutorial powers because I was elected. I'm a member of a party. As a minister, I'm a political figure, and I do believe that a political figure should not be involved in prosecutorial activities. My predecessor was the Minister of Justice of this country. My predecessor was the head of all the prosecutors of Georgia as a main prosecutor, general prosecutor of Georgia. And my predecessor was, of course, also, and I'll come back to that later, de facto chief and leader of the judiciary. So we separated the two. Today, what the Minister of Justice does is that I only have two competences: extraditions, and extraditions, every lawyer knows that is all about human rights. We do not have any right to extradite as it used to be after Georgia's independence in Georgia, to extradite somebody to somewhere in secret, or extradite somebody to somewhere where there is a death penalty. This is very quickly, of course, about extraditions and human rights. So extraditions are the Minister of Justice competence, and also supervision of human rights protection by the prosecutor's office, only whilst the Minister of Justice elaborates the general guidelines of their work. The judiciary. I'm very proud of all these reforms we have undertaken last year, and we continue still to reform the judiciary. The judiciary was not independent in Georgia. My predecessor would control it very heavily. I have here a small file to show you. This is the first time I show it to somebody. This is a file I found in my predecessor's drawer. And in this file, a judge whose name remains unknown reports to the Minister of Justice what he or she is doing for him whilst being a judge. So this culture is over. Today, judiciary is free. No single judge in Georgia can say that they know personally the Minister of Justice, or that I took my phone to call them, or I dare inviting them to my office. I met twice or 3 times, maybe 4 times, but very few times the Chief Justice of Georgia. And I did go to see him because he is the leader of the judiciary. And everybody in this country, including ministers, should learn to respect judges. So what we did, we depoliticized completely the High Council of Justice, where politicians and parliament members were sitting. In the past, today, no single parliamentarians, including Georgian Dream Coalition members, can sit in that council and govern the judiciary. And we closed the vote, which was open and was not secret. Today, the Conference of Judges, which is self-governance body of more than 200 judges of Georgia, they convene their conference freely, and they can vote secretly to elect members, judge members of the High Council of Justice. This is, of course, very quickly about the first wave of the reform. We reformed the disciplinary proceedings for the judiciary at the legislative level. Right now, we finished to draft the Juvenile Justice of Code for Georgia. Georgia doesn't have such a code for our children in jail, and we need to separate adult prisoners from our children who are sitting in jail, and to give them the right to have an access to a specialized judge who knows how to judge and deal with juveniles cases. We have already sent to the Venice Commission of the Council of Europe a package of reforms for the judiciary. It's about freeing the judges from their own leadership influence. In this file as well, you have the judge saying that I'm, as a leader of one collegium, I'm convening, dear Minister of Justice, every evening my judges to make everything possible so that tomorrow their decisions fit with what the prosecutor's office is asking. So we need free judges. We need judges who are not dependent on the executive, and they are not today. And we need judges who are also free from their presidents. A judge should be a free person. So we work for that, and I do have this impression of pregnancy, and I think that next year there will be a delivery. Revision of the criminal law, and I will not take much of your time about that. We reformed, and you should know that the plea bargaining system, which was a kind of system of blackmailing the defendant, today no prosecutor of Georgia is allowed to bargain with the defendant in a car or in a remote part of a building in dark places, or even in the prosecutor's office, without drafting minutes of negotiations and bargaining. We were in 2004 told that this was an American system, and we poor Georgians didn't understand that it was good for us. When we came to power, we quickly understood that this was not an American system, just the name was American. So we reformed the contents of the plea bargaining system, and today there is no system of nolo contendere. We just have bargaining over the sentence. And we try to discharge and help the judges not to be in charge of petty crimes. My colleagues gave me a huge list of reforms, but with Gogia's permission, I will just stop here. In order not to make him angry, because he is the deputy who helps me with international relations, international law, etc. I'll mention just that we are very proud of our signature, which happened several weeks ago. We signed at last the Council of Europe Convention on Fighting Domestic Violence and Violence Against Women, because women's rights should be more protected in this country, not only in terms of participation in politics, but also when it comes to domestic violence. And in that we continue to reform the prosecutor's office, because prosecutors are mainly men, and men think that husbands sometimes, not on all men of course, but sometimes men have this temptation to think that their wives are their property. This is not the case, I can assure you. So women need to be more protected in this country. And I should underline not only in politics. Of course, politics, like in every country, in Georgia as well, is a violent sphere for every woman, and it is violent, but we are much protected than an average woman in her family, which can be beaten up by her husband. So I do believe that very soon in autumn, Parliament will follow me and ratify this convention. I had the honor with my colleague to sign in Strasbourg several weeks ago. Thank you.
Thank you, Madam Minister. Giorgi?
Thank you, Mr. Chairman. Let me start by congratulating the organizers of this very important forum. It's been 2 years of very thought-provoking discussions. My intervention will be about strong states versus strong rights, and whether it is possible to build a strong state without at the same time protecting the rights, and how former and large and also the current government to a certain degree is failing in building the strong state without basing it on strong rights. Yesterday we heard Dr. Fukuyama's very interesting speech about what are the three constituents of a strong modern state, and he said that he would not explore the Georgia's example, and exactly that's what I will be trying to do, how those three main factors apply to the Georgian case. And number one was the state, and the strong state is about the legitimate monopoly of power, and two other key factors were the accountability, rule of law and accountability. So let me analyze each of them and show you why some of the reforms, very radical and very important reforms, were not as successful as they should have been in Georgia, and still need to be changed. One of them was a very radical reform of law enforcement, and we've heard a lot about how Georgia, after the Rose Revolution, Saakashvili's government inherited a failed state, and this failing of the state was largely because of the failing to monopolize the power, coercive power of the state. And in order to tackle this issue, the government of Saakashvili, because of the mandate, a very high mandate that it had, started with a very radical reform of firing, over 11,000 police officers in order to hire the new people and start the new practice. This is something probably impossible to do now, but this was with the government that came with a huge mandate and was able to do this in a swift move. And this was very much necessary. And we've also heard how the coercive power was actually monopolized in other fields of the state. However, unfortunately, what the government was failing in was the accountability part of this reform. And let me give you some of the examples. One of the first examples of this failure was in 2006, when there was a so-called prison riot in Georgian prison, and government used force to disperse this riot. And this was a lethal force where 7 people died, inmates died, and scores were injured. I remember then raising this issue at a very, very high level of the government authorities, and the answer was very straightforward that, listen, we had the prison riot, and there were people who dared to use force. And this was the first time. Never before we were able to use such coercive force when the state needed it. So if we are now prosecuting the people who dare to use that force, next time there is a prison riot, the prison system is going to collapse on us. And this was the justification for ensuring no accountability of excessive use of force by law enforcement. Unfortunately, this was the micro level, and next time there was another crisis in 2007 in November on the macro level. Then again the government used excessive force, and this time there was a perceived or real threat of coup in the country, and the response was also very heavy-handed. Again, there is nothing wrong with the government using that is again the very definition of the monopoly on the coercive force is that they are supposed to be using it when there is a perceived or real threat. However, they again failed to ensure accountability of those law enforcement that used excessive force against demonstrators, sometimes against very peaceful demonstrators. So then there were several other cases. However, the important part here was, as on the one hand, Georgia was building a very strong state it's able to use the power when there is a need. However, it was very weak when it was failing to prosecute those who were using it excessively. And in fact, the need for protection of those law enforcement even increased throughout the years, and we have seen how the legislation actually toughened in order to ensure that police was actually more protected. And this was even, when the administrative code in this country was, which is the remnant of the Soviet past, when the administrative imprisonment from 15 during Shvedov to 30 days was increased to 90 days, and it was possible without any due process, just on the police testimony, to incarcerate a person up to 90 days. And this was exactly intended to protect the law enforcement, actually. So the country was increasingly dependent on this power, which was actually created from the scratch. And for me, the manifestation of the largest, most actually telling manifestation of this was in 2009, when there was another a contradiction between police and public in front of the main police building, and when police was shouting Misha instead of maybe screaming Georgia, when there was this kind of standoff. And this was again, the allegiance of the police was towards the people who hired them, not toward the state. And this was largely because Georgia was largely failing on the accountability part. Don't get me wrong, there's nothing actually changed in this country in this regard. The current prime minister, when he was the minister of interior still a year ago, and then there was a first incident of the police officer possibly using the force against representative of the Georgian Young Lawyers Association. He did everything to protect this person. Unfortunately, up until now, there is no independent mechanism of ensuring accountability for crimes committed by law enforcement. The current system, the way it is structured, there's an inherent conflict of interest when general inspections are dealing with crimes committed by law enforcement. And I think this is one of the biggest tasks that this government still needs to accomplish. I think, and this was not the lack of accountability did not manifest itself only within the building of the law enforcement structures. I think this is something that was evident in the past and still evident currently, is that when the former government came under a very huge mandate of reform, and they felt under enormous time pressure to deliver. And they were willing at a great extent to take the shortcuts in order to achieve the greater goals. And we already heard here in the past presentations how the means don't always justify the ends, how unfortunately this was what was happening in many fields of this life. For example, and this is also something, for a very familiar case for the Georgian public, it was that, a case of a demolition of a high-rise, an apartment block in the city center, Tabukashvili Street, for those who remember probably this case, is that, government was in a rush to deliver the investment. And there was this building where people used to live. And instead of going the rule of law way, instead of approaching each tenant of this apartment building to negotiate the settlement, and this would have taken maybe, many of them would have agreed, some would have disagreed, some would have taken into the court, and would have been maybe taken months or maybe even years, but investment would have come later. What they did was they actually started demolishing the apartment block with still people, living inside, largely not physically, but largely still living inside, and giving them one choice only in the end because the block was gone. But the investment came immediately. Now, is this the? To me, again, this is not the way strong state is built, because the strong state requires strong foundation. To me, the foundation is the rule of law. The foundation is the accountability. So once you start taking these shortcuts, actually, you are not the state is exposed to the weaknesses. And unfortunately, to return to the present days, the current Georgian leadership also came under a lot of pressure to deliver on justice. So-called restoration of justice was something that was largely, the current leadership came on the wave of this promise, and there was the pressure from the public was very high, so the temptation was very high to take the shortcuts again. I mean, some of the high-level arrests, former government officials, the way it was handled, where, for example, the pretrial custody was done, whether in capital or in the region, or the charges on which they were initially detained, and then aggravated. It also showed how much in rush the government was to deliver so-called this restoration of justice. It's very important that, again, when the government feels under a lot of pressure, there is extremely important to still stick to the rule of law, to still stick to the supremacy of justice. Because once the government starts taking the shortcut, these shortcuts are on the side of rights, and eventually the state, the strong state, the modern state, is not built on that. I firmly believe in this. I'm sure this is something that can be largely debated, and there will be some questions, and I would be more than happy to answer them. Thank you.
Kakha?
Good afternoon, ladies and gentlemen. It's a great honor to me to be here and to participate in this very interesting and useful forum. I would like to start with emphasizing on this title of our forum, Building a Modern State in the 21st Century. Like any conscious act of a human, the act of building a modern state as a huge act is also have its own particular aim. Why and what for do we build a state? You know that philosophy and legal theory do have various of answers to these questions, but we, however, have our very clear answer to this question. This answer is very clearly written in our Constitution, in the preamble of our Constitution, which states that the firm will of Georgian people is to build a democratic social order the rule of law-based state, and to secure universally recognized human rights and freedoms. And of course, the Constitution of Georgia is not an exception. The constitutions of various nations contain the same implications. But countries differ with each other, not for what is written in their constitutions, but how they implement in their daily lives this very important principle for state building. I mean, the protection of human rights and protection of rule of law. I think that the strengths of any state can be measured by whether it can answer and it can overcome the key challenges of the history, the given time in the history. And for centuries, for Georgia, the key challenges was related to the military action, as it was the only way to survive and for our physical survival, it was an only way. And today, I believe that for today's Georgia, the key challenge is the protection of human rights. And this thought is based on the understanding that free and secure person can bring more good for himself, for state, and for society. And at the same time, a state inhabited by free and secure person, by successful persons, this kind of state also has more chance to be successful too. The key role in the protection of human rights and rule of law, as the previous speakers mentioned, of course, is played by law enforcement bodies. It's their primary work, you know, and but in daily practice, if they preach the importance of rule of law, but daily if they breach this principle, of course, it will not build the rule of law and the trust towards law enforcement bodies, which then this trust is mentioned by Professor Fukuyama yesterday as the most important thing during the state building process. That's why Georgian Young Lawyers Association is trying to monitor the activities of law enforcement bodies and not to allow them to make mistakes, harmful mistakes for state building process. That's why we are advocating the idea to create the independent independent organ to investigate those crimes allegedly committed by law enforcement bodies themselves, the representatives of law enforcement bodies. Giorgi mentioned the concrete fact which took place last year, but unfortunately it is not an exception. Georgian Young Lawyers Association, also public defender, have numerous facts when we have information from concrete citizens, when the crimes are allegedly committed by the law enforcement representatives of law enforcement bodies, these cases are not properly investigated. And if law enforcement bodies are not objective, are not neutral, are not effective, this, of course, will not build but will ruin the trust with them. That's why we are advocating this idea to create independent organ to investigate this kind of crimes committed by the representatives of law enforcement organs. That's why we advocate the idea for alternative monitoring mechanism in prison system and so on. And now about judiciary. Previous speakers mentioned the importance of judiciary, and of course the judiciary has crucial importance in modern state building process, and I'm sure that never in any place would have huge violations of human rights if judiciary can preserve its own constitutional function, its main constitutional function. And unfortunately in Georgia, judiciary has had systemic problems. And eventually it could not fulfill its own main constitutional function. And this fact that judiciary could not fulfill its constitutional function was clearly seen by the fact that the restoration of justice, so-called the restoration of justice, was and is one of the main demands of people in Georgia. And judiciary was under the control of executive and concretely under the control of prosecution. And the Georgian Young Lawyers Association, in every 6 months, we represent the court monitoring reports, and based on the result of these reports, I can tell you that we have significant improvement in judiciary. This improvement is because of political process from 2012, because of legislative changes initiated by Ministry of Justice, because of years-long work of civil society in this country, and of course because of our international friends and partners. Of course, these positive changes is accompanied by significant challenges and by significant shortcomings, but positive development is obvious, and it gives us the hope that we can overcome the ongoing obstacles too. So indeed I can describe the ongoing problem in more detail, and if you have questions because of time limitation, I will stop here and I will open to answer your questions. Thank you.
Thank you, Kakha. Irakli?
First of all, I would like to thank you for inviting me to this panel. I think we're touching a lot of issues which are interesting, but at the same time pretty debatable. And I would also say that some of them are actually questions that definitely cannot be answered at this panel. But I would like to pose a few questions myself and then try to kind of put that into perspective that I think is valid from my point of view. The state building and democratization, where it starts and how it starts, what are the prerequisites, and then how that happened in Georgia. Well, my view is that everything should be contextualized. I think we have to be contextual, which means that we have to read through the difficult, I would say, background that Georgia went through and is still going. For me, this process is not an end game process where you see one day that today we have reached that point. I think we are talking about a continuum. So from that point of view, I do see Georgia having some of the very interesting things happening in a very condensed time. And I guess many of us have talked about it, and I would actually say that some of these achievements, maybe failures as well, are textbook examples of how a state can become a state at firstly, and then how it actually can evolve. So I just don't want to go back to what we were in 90s and how we all started. I guess all of us remember that, which means we were weak as a state. We were incapable to deliver what all of us wanted at a certain point. How that changed, and I have to say that the 2004 has been an important stage for creating a modern state. The modern state, in a way, we do understand it, where the transformation and modernization has been the key priority, and which actually gave fruits in about a matter of certain years. Of course, the modernization and then the creation of new rules is rampant and is prone to produce lots of mistakes, but at the same time to produce lots of things which will give you a sense how to evolve and how to refine the system. I think at a certain point, every country goes through the stages. And I myself is a proponent of a school of thought who thinks that without state, you cannot have a functional democracy. I do believe so. And I think that's very, for some that might sound to be very, I would say, impersonal. For some it might sound that, oh yes, but come on, there are so many other issues that you have to be considering, but that's true as well. But we talk about the sequencing and how that happens. At a certain point, I think through the transition that Georgia has been transitioning, I think the democracy building should be the key priority. And of course, here I would like to talk about the way we should proceed. I think most of the talks that we have been listening to are about what it was really and how we are. And not a lot of people have been talking about where should we go. I think one of the biggest deficits that the political spectrum in Georgia is in my opinion, suffering from is actually the lack of positive agenda. Let it be both parts of our largely big players. You know, I'm talking about the coalition which is in power, but also the opposition. I think we don't talk about how we should move forward. And most of the agenda for the ruling elite right now is to smear and to shame the previous elite and to create this ostracizing of the opposition, which doesn't really happen to help the idea that I think was mentioned by Madam Minister about the political, inclusive political system. I think all of us should be talking and thinking about how to move forward and create those prerequisites and basis for the system which is going to be inclusive. Here I definitely think that, you know, in a very strict sense of rule of law, I mean, you need a procedural part to rule of law, which are the formal rules, formal institutions which help you to create a state, but also processes which help the state to function. From that point of view, of course, I think personally that one of the things that we lack is the proper system of the elite turnover, where all the elites, the political elites, the elites in the civil sector, and other parts of Georgian society can be part of a political game. I think all of us should understand that the next agenda should be about that. I think right now when I'm looking at the political spectrum, not a lot of people are in that mode of thinking. And I can actually elaborate on this. I just don't want to be going in depth, but it shouldn't be about zero-sum games. I do think that it should be about this concept of the mutual security, which is the Robert Dahl's term, which basically creates a consensual idea between the elites that we agree about certain rules which will help us to be governing the country according to the known rules to us, but also to the wider public. I think that should be an agenda in a strict sense. Of course, we're going to be having lots of tests on this road, and I think that electoral processes are one of the biggest components to that. I think 2006 elections are going to be pivotal, with all due respect to the previous 16 elections are going to be pivotal elections. With all due respect to the previous two elections, the local one and the presidential one, I think there were inertia elections where there was a sweeping understanding in the public that there should be a change which would be associated with kind of the new wave. But after 2 years, we are going to have a very different political situation. That's going to be the true test for the authorities which are in place right now. And I think on that road, there are many things to be looking at, and one of them is actually the next electoral commission composition, which is going to be rotating pretty soon, as you know, and the so-called non-party members are going to be rotating, and the true election and the true selection of the right configuration there is going to be extremely important, and that's going to be a test for the authorities to be judged against. Also, I mean, when we talk about the consolidation phase, we cannot talk about the so-called restraint mechanisms or the mechanisms which actually limit power. We have been talking about many, about many issues and many concepts here, but I also think that the judiciary is one of the biggest pillars to this. I do think that with we have to be fair to evaluating what has been the problem and where should we be going. I think that the problem that to a certain degree and maybe to a larger degree the judiciary has been very much not independent, as many people are saying, was a side effect of the state building. And I think that in a way is creating a new reality, which is it shouldn't be a crusade against the judiciary itself, but it should be a reformation. So I think if we're trying to refine the system, it shouldn't be about dismantling the system. It should be about the refining of the system. Because the judiciary, as it was before, was an incapable institution because it was not able to enforce anything. It was widely corrupt. It was extremely not competent. And at the same time, it lacked any infrastructural base to be a modern judiciary. There were a lot of problems, and no one can deny it. But the time comes for the authorities to move forward with an agenda which is not going to be about consolidating power, but consolidating democracy. I think it's extremely important because if the authorities, the coalition which is in power right now, is going to go through maybe the same path of not understanding the real essence of judiciary, because I think, my personal opinion is that I think that the previous government had an agenda of going forward with reform, but it was postponing it because of the systemic crisis. That's my theory. Of course, in the end, it didn't serve the purpose. It created lots of repercussions for the ruling elite itself. But I think we shouldn't be going again to repeat the history and these processes. I think that's going to be very pivotal, and the next year is going to be very pivotal because the Chief Justice is going to be stepping down. There is going to be a whole new dynamic. Unfortunately, I cannot share the optimism that the judiciary is free from any influence or it hasn't been it has been, like, let's say, perfect in relationship with other bodies. No, that's not the case. I think that there are lots of transgressions there as well, and that's the point I want to make about judiciary. Once again, I think there are other parts of a pluralistic environment which should be very importantly being brought to the discussion. I think media is important. I think we have been discussing a lot of things in Georgia, but I myself think that media is one of the most important channels of communication, which in a way has a huge role for a pluralistic environment in the future if we want to retain. So I think there as well, everyone should be aware that there shouldn't be any let's say, non-pluralistic acts against any media outlets. I think it's extremely important to preserve a mosaic of various media outlets, let it be the print, let it be the other electronic media, TV, etc. I think that's going to be extremely important. And just to be also talking about the rule of law from its essence, I think one of the biggest determinants of rule of law is the equal application of law, equality of law. I think we shouldn't be going through, Erik, you like to talk about this. I mean, we have to be very much about having the law which is going to be applicable equally to everyone. And we shouldn't have the maxim that, you know, everything to my friends, the law to the enemies. You know, I think it's extremely important to go beyond that mentality. Unfortunately, I have to say that political spectrum is prone to go forward with that. I do think that we lack consistency, legal consistency on all sides. We definitely don't see validity or veracity of arguments sometimes when we see that, you know, the application of the law is not perceived by public most of the times. In a way, we have to be doing this. I think we can bring lots of examples of this. Once again, and this is not peculiar to this time. I'm pretty sure that we can find lots of instances all over again. But I'll just end with the few remarks. I think, just to kind of summarize, we have to be thinking more about the future, the fabric, the social and political fabric which we are going to be creating more than we do right now, because we don't. And the other thing is that the point was raised that it shouldn't be about personalities, but let's be very frank, right now the personalities are no less important or no less influential than they were before. And I think we shouldn't be denying this. I think if we really are trying to build a system where the personalities don't exert too much power, or they should exert the power they're assigned to, we definitely should be thinking about what are some of the informal networks or informal, let's say, structural problems that we have right now. We also have to be thinking about it as well, because I do think that the politics now are also very personal. And once again, I have a point to make about not ostracizing the state building. I think state building is great. I think that the state capacity is absolutely necessary to be democratic as well. I think there is nothing wrong with that. I think we should be talking more about the institutional continuity and sustainability. There is always room for refinement. There is always room for improvement, but it shouldn't be about revisionism. It shouldn't be about going against what has been achieved. It should be about building on it, on whatever is good, not about dismantling what has worked, what has made us known, but what has also delivered very, very tangible results. That's it, and I'm ready to go forward with the Q&A. Thanks.
So I could take one of two paths. There have been a diversity of views expressed in this panel, and we could have a debate among panelists, but I'm actually tempted to go another route, and that is to solicit a few questions from the audience, and the panelists then can fold in their responses to each other as we receive questions from the audience.
My name is Gregory Shvedov, and I'm from Moscow, from Caucasian North. We are media which covers the region. And I was about to ask this question yesterday, but since it was a highly political session, I decided to ask our respected human rights defenders, and specifically the minister, about one case. My interest is not political, please excuse me. That's why I was not asking this yesterday. I'm wondering how investigation of Lopata Lopankuri case is going on. I understand there is a political side in this, probably, but in terms of rule of law, what's the role of independent human rights defenders to keep an eye on this investigation? What's the role of bureaucracy in also taking a lead in having this investigation being resolved? Just for my colleague fellows, it was a major breakthrough with the investigation of one case. Maybe I would not correctly describe it. Please excuse me, since the Georgian colleagues would describe it definitely better. Then during elections, then Saakashvili actually lost his power. It was a case about Northern Caucasian terrorists, which by the mainstream theory was coming from Russia, from Northern Caucasus, and attacking Georgia. But based on independent investigation by local journalists, Caucasian Note, and later Ombudsman of Georgia also filed a report. Those people haven't came from Northern Caucasus, but it looks like they've been somehow organized here in Georgia. I believe that's a very important case for democratic Georgia, because there is certainly some responsibility, as I think, of the previous government of Georgia for this case. And if something would be done by the current government, that would show that state works on issues which looks like a taboo topics for me. And if nothing would be done, if investigation would die in someone's prosecutor's office, that would mean a lot in terms of responsibility of a current state. And I know that's a very sensitive topic. That's why if minister would not answer, that's fine for me, but maybe human rights defenders would say, are you keeping eye on that? So what's your vision? Is it needed to investigate a role of officials in this case, or it should go as it's going? Thank you.
Good evening. My name is Varvara Pachomenko, and I'm also from Moscow. And I also have a question about the investigation of previous cases, particular investigation of violations during the war between Russia and Georgia in 2008. I know that the cases of violation of rights of Georgians, those who were killed during the war, or just cleaned from South cities, it's not happened in Russia. But what is about the investigation of cases where Ossetians are victims and Ossetians suffered during the war? Does it happen now? Because it almost didn't happen during the previous government. And what is now? What's happened now?
And then one question from a Georgian. Do we have a Georgian in the audience? There we are.
Hello, Tsulukiani, Economic Prosperity Initiative, USAID project. So my question is regarding property rights. We know that one of the cornerstones of economic development in democratic societies are strong and consistent judicial system, and it includes one of the major components is property rights. Unfortunately, the previous government had quite a bad record on property right violations. And my question is to the panel participants: what have been done during this time, during the new come to power new government? What they made to institutionalize protection of property rights? And also, I'm interested about the NGO part of answer to this question. Thank you.
First of all, I would apologize, but I do not think that I'm here to discuss with you the individual criminal cases and individual circumstances of a criminal case. However, of course, I do think and I do stand for that position, which is to claim very loudly that there should be no impunity, that every single case which needs to be investigated should be a matter of effective investigation, not only of an investigation, but an effective one, which should be quick also. This investigation you mentioned is everything but quick. So this is also a problem. Now, when it comes to the notion of effective, I do know, despite of my abandoning of prosecutorial powers last year, that investigation is pending. That's all I should know. I'm very much delighted to know that human rights defenders and the Ombudsman of Georgia is very carefully watching that. and the Ombudsman of Georgia will be delivering his report on the Lapan Uri case in September. This will be, I do hope, a case of exemplary cooperation between the state and the Ombudsman of Georgia, which is a state institution still, but somehow has enough independence and is somehow a human rights not only defender but also watchdog. So I do think that he can give some help also in his report awaited for September. As far as I was listening to all of you, and I asked myself one question. If we have in the room Georgians, of course they do know what we are speaking, all those Georgians present here, about, but maybe for foreigners it can be quite difficult to understand what, for example, the very well-known word of restoration of justice can mean at all. Because restoration of justice in English, I do not think it means anything. Georgians, when they mention it, they, at least as an elected person, I do know, in my constituency on one of 140,000 people, what those Georgians meant by restoration of justice. They meant putting all the judges in jail because they were not independent under the previous government, kicking out all those judges from office and replacing them by new judges, arresting all the high-rank former officials, and returning back all properties, and you mentioned the property issue, taken away illegally by the previous government. This is, for Georgians, restoration of justice, because, as I mentioned in the beginning, very diplomatically, the former government lost the election in 2012 because there was massive violations of human rights. Prisoners, including juvenile, were raped in jail, and I should apologize to mention the past, but this was part of our past. Our children in jail were raped. Our men in jail were raped. So rape was a problem in Georgian jails. Massive violation of human rights in Georgian jails, and I do know because I examined, as I mentioned in the beginning, hundreds of cases whilst being a case lawyer at the Strasbourg court, examining Georgian prisoners' cases brought against the Georgian case, the then government. So I do know, and I apologize to speak about the past. This is our past. There were many shameful things in that past, but there were good things as well, and I do agree in that with you. So that's why I need to explain that when I work as a Minister of Justice of this country, I take everything which was positive and I do try to develop it and to prepare this for a next Minister of Justice. And I do not think, in difference with my predecessor, that I will stay in power for 50 years. That's what he was teaching to his colleagues when he was in power, even if he was a very clever man, but he was far from being a Democrat. So now, when it comes to what changed, and when one can speak about the government's obligation to work on the future, yes, we are working on the future. What disturbs us whilst working on the future is the past. Because in the past, in Georgian jails, when we came to power, we had more than 20,000 people in jail. For a very small nation, it's too much. We were criticized by the CPT. We were criticized by everybody that we were in Europe in first place in terms of numbers of prisoners. What we did, because we think about our future, we halved the number of prisoners in Georgian jails. What we did for the future of our children is that the Ministry of Justice, because it was the government's political will, first time in Georgia elaborated former prisoners program, because these people, when they came out from prison, they were just in nature, they without no care. without any care. So we decided to have this so-called rehabilitation and insertion program. Georgian state did not have. So yes, we are working for our past, for our future, because our past was not that glorious as somebody can think. What we are keeping and developing is different good things. For instance, state services delivered quickly to our citizens, and tomorrow I'll be honored to host you, the delegation, at the Public Service Hall to show you what the former government did and what we are doing to continue the good path. But there were things when I didn't mention, sir, that the judiciary is perfect today. But what I mean is that today the judiciary is far better in a good shape, because this report from a judge to my predecessor reads as follows. Dear sir, I'm examining every evening the criminal cases in person. I decide with the judges what kind of judgment we should deliver the next day so that we are in compatibility with the prosecutor's position. That's it, written in Georgian. This doesn't happen tomorrow anymore. And I do think that it's a huge step forward. Now, everything is not perfect. As you mentioned, the Chief Justice will be changing next year, but I do not think it's a main problem today. The Chief Justice is very happy to be free today from the executive, and he's doing everything in his best to help the judges to enjoy the freedom they have. I should agree with Mr. Kozhoridze when he mentioned that an independent investigation body is needed in Georgia. I do not agree, however, that GYLA has numerous cases. GYLA has cases, a number of cases, but GYLA doesn't have numerous cases. But even if we have one case, even if we have 2 or 3 cases, we do need a body which is trusted, which is independent. And every human rights lawyer knows that investigation does not mean anything if it's not free, independent, and if it's not trusted. So the Interagency Council I'm chaired, which is working against torture, proposed and asked different stakeholders, including the Ombudsman of Georgia, the Penitentiary Ministry, etc., to elaborate a new system in which we will have such a body, so that when policemen commit something against a citizen, the policeman himself does not investigate this case. Of course, it should be done, and it's part of our future reforms. And to finish my answer, what changed? In Georgia changed, especially in the Ministry of the Interior, in the Prosecutor's Office, in the Ministry of Justice, in the so-called law enforcement ministries. What changed? Under the previous government, there was one case brought before the Strasbourg court. This is the case which demolished and devastated the former government. It's called Tsulukiani and Giorgi against Georgia. In that case, the Strasbourg court said, and I'm quoting, that the then president of Georgia, the then Minister of Justice of the Interior, who is in jail today, the then head of the penitentiary, the then head of the judiciary and the judges, everybody acted in concert to prevent the justice from being done in that gruesome homicide case. This is the quotation. Now, the legacy I received as a Minister of Justice from my predecessor is this judgment. And what I should do to execute this judgment, because every year, I should go to Strasbourg and show what I did in order to execute that case. What should I do is to investigate this case anew. That's what's underway today. The Giorgi case was opened. And today, even if the GYLA has some cases of violation of human rights by the policemen, that's true, and we need an independent body. The new thing is that no such a judgment can be delivered against Georgia in a case in Strasbourg. This is new. This changed. We do not have rapes in prison. And what we are doing now, we are not violating our children's rights in prison, but we are, for our future, working on the juvenile justice code. So all our work is about future, but the only problem I have right now, and I have been having it since 2 years, is our past, because past is catching me every time. And tackling with the past, managing the anger of the Georgian population against the former government and against the current big government, because we are not putting everybody in jail from the former government. This is a huge anger in the Georgian society, and every day we are managing and trying to manage that anger, because the rule of law needs to be protected. We did not kick out every judge. We kept every single judge the former government nominated, but we are reforming the judiciary by laws, not by kicking the judges from their office. That's what the former president and former Minister of Justice Saakashvili did. He removed all the judges in the name of the rule of law. This is not how the rule of law works. We need to keep the judges where they are, and we reform the judiciary, the rules, and practice. This is our understanding of reforming. The Georgia versus Russia case and the August war case. Let me in the end answer this question. Even if I fought the former government, and I will continue to fight the former ruling party even from my grave, I do think that they did good things sometimes. What they did is that they began investigation of that case in 2008. No one should be allowed to say that this government is so clever that it started investigating the war case today. No, that's not true. The former government, who has this big tragedy with the Georgian people to experience the August war against Russia, who invaded Georgia and occupies until now the Georgian territory, they started, despite many difficulties, investigation of that case. Investigation of what? Not investigation of the fact who started the war. We know who started the war. I do know. We were invaded one day. But we need to investigate human rights violations. Whoever the author can be, Georgian, Ossetian, or Russian. Human rights does not know ethnicity, and it does not differentiate according to political beliefs or ethnicity. So we do have this obligation to investigate. Russia does not have any obligation to investigate because it refused to join the Rome Statute. So they are not part of the Hague process. We are part of it. So Russia does not have any international obligation to investigate the war. No international obligation. No. We have that obligation. Yeah, you asked, I'm answering. So we have this obligation. The former government was very well understanding that. They started the investigation, but it's a very, very complex case. One part of the investigation has just finished. We are continuing to investigate other, the so-called, as lawyers call them, episodes of the case. What I'm afraid of as a Georgian and as a Minister of Justice of this country is that the International Criminal Court will not be waiting until we finish the investigation, and they can take this autumn the case to The Hague. So we are doing everything possible to be allowed to continue the investigation in Georgia, because my credo is that human rights violations should be tackled inside the country. That's why when I came to power and to the Minister of Justice, we finished all the human rights cases in Strasbourg with a friendly settlement. We do not litigate in Strasbourg anymore with our citizens. We finish every single violation case between the state and the citizen of Georgia with a friendly settlement. We acknowledge, we You know, the Strasbourg case law. Acknowledgement of violation, apology, and compensation. That's what we are doing. And it's completely new. It's about future. But the past was a big shame, despite some positive things which have been done. So investigation, yes, but with a huge fear from my side that the Hague Court can start investigating that case independently from us.
Giorgi.
Thank you. First of all, about Lapankuri case. Georgian Young Lawyers Association is protecting the rights of the victims whose family members were killed there. And we advocate their rights, and we see the shortcomings of investigation, and we are trying to ask, and every week we write different kind of statement and announcement to the prosecution office, and try to follow the investigation process, but we see that the investigation is not effective. That's why we are going to take this case in the European Court of Human Rights if in these months, during several months, we will not see the results of the investigation. So this is a problematic case, I agree with you, and very strange case. I, of course, don't know what happened there, but I know that people were killed there, and I know that the state should investigate that case, and I know that the investigation has shortcomings to our mind. About the investigation and the numerous facts of Georgian Young Lawyers Association. Yes, we have approximately 40 cases where concrete individual citizens are speaking about the violations of their rights. They are physically beaten, as they are speaking about, by police officers or by staff of in the prison system. And other 40 cases has public defender. I think that in our country, these 80 cases are numerous. And also the problematic thing is that the approach, what is the approach of law enforcement bodies after hearing the information and from public defender and for human rights defender NGOs, what is the reaction? And restoration of justice for us also means the change of the approach and the change of the reaction of law enforcement bodies. But I want to remember one concrete example at the reaction from prosecution office for this kind of cases. It happened 3 days before the Easter this year, when public defender spread information about the fact that, and the information of public defender, some prisoners were beaten in prison system, and the public defender made public statement about it and asked prosecution to begin investigation. And the concrete journalists then went to the prosecution office and asked to comment about this fact, if the prosecution is going to begin investigation. And the comment of the prosecution office was that, you know, today is Friday, and that Friday was the rest day because it was the Red Friday. For Orthodox Christians, it was the rest day. And today is Friday, and the day after tomorrow is Saturday, then is Sunday, and Monday is also rest day. And on Tuesday, we will see that announcement, and on Wednesday, some or one concrete prosecution will begin studying and investigating this case. This is the problem. This is problematic approach, of course, and we, of course, do not have the expectation that in one fine day we can create the system where none of the law enforcement bodies and none of the representatives of law enforcement organs will never violate human rights. But we have expectation, and it's our demand to create the system where system is trying to do its own best to investigate and not to hide these kind of cases. And about the property rights was one of the questions. Yes, in Georgia, the property rights during several years was one of the oftenly violated rights. And GYLA, other NGOs, our partners have many reports about this, and a lot of applications were submitted in the prosecution office to investigate these kind of violations. And only the fact that, according to the former chief prosecution, approximately 10,000 concrete persons gifted their immovable property to the state. Only this fact indicates how problematic the property rights was. And of course, I think none of in Georgian believe that these 9 or 10,000 people voluntarily gifted their immovable property to the state. And this is huge problem, because on the one hand we realize that state budget is for state budget it is impossible to compensate this whole number cases in one day. Of course it is impossible, but we try to convince our government that this is very important to study these violations, to analyze what is in number this in money amount of this problem, and then to have realistic plan during several years and to compensate these violated rights. And for the first step, it should be done, for example, that some part of this immovable property is still under the hands of the state. And for the first step, we ask our state to give back this property to their former owners. But we see the reluctance of the state organs to do this. And we to take several cases in our court, and now the representatives of new government are trying to justify the actions of the former government, not to give back this property, but justify that we cannot prove that it happened violently several years ago, and we can't prove that these people were forced to give their property to the state. This is, we have several cases, and in court materials, the representatives of Ministry of Economy is trying to my mind, to justify the former wrongdoings. So it's very difficult problem. It's real, but it is a problem which needs concrete reaction.
Giorgi or Irakli? Surely.
I'm sorry of usurpating this right, but when it comes to deprivation of property under the previous government, that's true that we had more than 10,000 of cases and complaints when we were nominated in our respective offices, myself and the main prosecutor of Georgia. These complaints are not all about the deprivation of property, but about torture, ill treatment, deprivation of property, unfair trial, etc. All these complaints were accumulated at the main prosecutor's office, and they made a systematization work which has just finished, as far as I know. And it appears to be several hundreds of those complaints are actually about deprivation of property. For our foreign guests, I would just give an example, because they can wonder how it comes that the former government could deprive somebody of his or her own property. The then general prosecutor of the country would call somebody, a businessman, preferably, rich one preferably, and he would ask, you go and build such and such building for the state, or else you would go to jail. One or two businessmen who would refuse, they would go to jail, and they went to jail. And we freed them when we came to power, thanks to our big amnesty law. But others would abandon, either they would go and build, or they would go to the public registry and abandon their money, property, in favor of the state. For instance, cars. When we came to power, we discovered that dozens of illegally deprived cars were at the prosecutor's office. And the main prosecutor of Georgia called all those citizens and returned those cars back. It was done by Ms. Gvilashvili, the former main prosecutor of Georgia, in 2013. So he called all those citizens saying, look, these are your cars, they were taken away from you illegally, so take them back. And they were returned. It was an easy case. There are more complex cases where we have new owners in good faith because the property was resold. And this is the huge headache for the state, because everybody knows that when you have a new owner who is an owner in good faith, you cannot deprive him of the property. But when it comes to the property in hands of the state now is studying the possibility to return this property back. So when we speak about future, over and over, we come back to our past. That's why our work is quite difficult. So, and hand in hand with the civil society, I'm sure we'll resolve this problem as well, because the property rights should be protected in this country, and you are completely right. Thank you.
My name is Kakha. Let me first introduce myself. I'm former high official working in, used to work in Ministry of Justice of Georgia previous years. Now I'm defending interests of former ministers and high-ranking officials of previous government as a defense lawyer. I have a couple of questions to Justice Minister and to my colleagues from NGOs. I'll try to be short, because I know that time is limited. First of all, we know that this panel is about the rule of law, and from my understanding, rule of law is the order where no one stands above the law. And in Georgia now we have some interesting situation when billionaire, former head of, official head of coalition Georgian Dream, openly says that president is asking permission to veto the law. Then Speaker of the Parliament is trying to search for MPs to override this veto. And Prime Minister doesn't need to be said twice to follow orders or requests of this billionaire. who has no official power. So one question is about who is running the country. And is this person above the law and above the responsibility? Or do we, the citizens and members of the society of Georgia, have the right to, ask for, to resign this billionaire or to kind of apply some political responsibility on the arms of this billionaire? This is first question. Second question is about this case file, which is brought. Congratulations, Justice Minister, because previous times only gossips and rumors were the grounds for these kind of allegations. Now the official evidence will be, I'm sure, that will be brought to the court, and I will see this case, the reports allegedly submitted before the Justice Minister. And I have one question. Why didn't you start investigation and open the case against the Justice Minister? Because you just recently mentioned that he was calling to the businessman and was depriving the property, cars, etc. Why there is no case against Attorney General, former Georgia? Because it's almost 2 years after you are into the power. Another question is also a small one, but very important. You just mentioned child rapists. And could you please explain what was the reason you, your ministry and prosecutor's office dealt procedural agreement, plea bargaining with the main raper of children with handicam and stick, Vladimir Bedukadze, who was the main perpetrator and main torturer, and he was not convicted even. I'm not saying about formal charges or the sentences. And very last question is about judiciary and restoration of justice. I'm sure that all English folks, they understand what means the word restore. When you used to have something, we used to have judiciary which was independent, professional, and just, and we used to have like prosecutor's office, also professional and just and fair, and United National Movement and previous government like abolished this system and created wrong things, and we just need to restore the justice. This is what restoration means, and what do you mean under restoration? And very last thing needs to be mentioned is that very trusted NGO, International Society for Free Elections and Democracy, reported that you, Ms. Justice Minister, has openly stated that your political force needs to eliminate United National Movement as a political party. In Georgian, it was ganadgureva. And what did you mean under elimination under this word, and what your political force mean under this word? And the question for my colleagues in NGO sector is about current problems and current challenges in human rights field and rule of law field. Because, of course, it's good to make qualified analysis of the past, but we should also consider that it's almost 2 years since new government is in the power, and this is a lot of time. This is half of their term, actually. And it's time to identify what are the challenges. And I want to ask the question to my friend and colleague from GYLA. What do you think about about prosecutions, large-scale prosecutions of former ministers of previous government. And probably audience knows that almost every member of the cabinet is under prosecution. Some of them are serving their pre-trial detention, or some of them are even convicted. And I know that GYLA has published in 2012 a very detailed report about presumably politically motivated cases, and this were about very low-level, allegedly political cases. And now we have the case where almost every international organization and our friends from Europe and United States say that they have perception that these cases can be politically motivated. What do you think about this? And what are the current challenges in human rights field under new government? Thank you.
I have a very short question.
Very excellent.
We all know about the process of this process, which is called the restoration of justice, which is sometimes evaluated by some people as the policy of revenge. And the question is, why, as a starting point for the restoration of justice, the current government has chosen 2004? Doesn't mean that there were no violations in the Shevardnadze period. As we know, a lot of people were thrown out of the window of prosecutor's office. And are these cases being investigated? And if they are not, why? And one more question. Recently, the conductor and director of all this, violations of human rights, received his, without any problems, Georgian, and he didn't receive, but he was given a green light for restoring his Georgian citizenship by Minister of Justice. For which merits did he get this privilege?
All right. Madam Minister, do you want to start? We'll just have final reflections and answer the questions you wish to in the last harvest.
About elimination of the UNM. I was running in one of the constituencies of the capital city of Tbilisi, where the UNM had a former Shevardnadze ruling party person as a representative, MP. And in that constituency called Nadzala Devi, with 140,000 voters, where I was running, there was no Rose Revolution. This person was a kind of a local pasha, excuse me the word, and with no accountability before anybody. And thanks to the then government's help, this MP could free different people from jail and gain the votes in such a manner. I was running there, and I do remember that as a woman candidate and as a single woman living in a village, I was followed by the secret services of your government, sir, at that time. And they would await the then Kudi with their big cars at my home to scare me in the night. But not only I was scared, but I continued to fight. And I continued until the end, until I defeated that MP and I eliminated his presence in that constituency. This was a very good victory with 72% of votes for me. And this is a political elimination of your representative's presence in that constituency. I wish in 2016 the victory will be with us, so that we continue our work for future. So that when I leave Georgia, or I leave, because I came back to Georgia to fight the UNM rule in this country, to fight the violations of human rights your ruling party was author of. Once I think that human rights protection in this country is on the good path, Once we have this independent investigation body, once we have returned back the property you took away from our citizens, because you didn't mention that you was the deputy minister of justice, the deputy of that man who fled the country because of those violations he committed on the 2 days after the election. He fled the country, he fled the ministry, he left alone all those civil servants I'm continuing to work with. Yeah, once it's done, and I'm sure as a human rights defender that the rule of law work is on the good path in this country, I'll stop being a minister of justice in this country, and I'll stop being part of the Georgian politics. I came back to Georgia to fight violations of human rights, to fight violations of rule of law. So I'll continue my work until I'm sure that everything is on good path. So we work for future, but the past you created is catching me every day. So about Bedukadze. Bedukadze, of course, was one of those people used by my predecessor to manage different ugly things in the Georgian jail. This was the only person who cooperated with the prosecutor's office to dismantle on all this so-called omerta rule in the jail. What the then main prosecutor did, who was at that time the main prosecutor, yes, you are right, he signed a plea bargain agreement with this person, saying that it was because of good cooperation with this person who was the defendant in that case. If you remember well, and you are young and you should remember, I came out and condemned publicly the signing by the main prosecutor of that plea bargain agreement. And this person is no more the main prosecutor of this country. So what's the difference between you and me? The difference is that when this government commits errors, we have this ability to correct them. You didn't have that ability to correct your own errors. Not only you didn't have this ability to correct the errors, you didn't want to have it. The Giorgi case is the best example of that. The then government, killed Giorgi. This was a young guy who was killed in the Okrokhana. Yeah, don't get upset, he was killed. And there was no investigation. And the Strasbourg court said that every minister, Mr. Saakashvili, and the judges acted in concert to prevent the justice from being done in that case. You did not do anything. You was at that time the deputy minister of justice, in charge of executing the Strasbourg court judgments. You did not do anything. So this is the difference between you and me. We have this ability in this government, when we commit errors, to do everything to correct them, to acknowledge that we did errors. You did not acknowledge even today, sitting here, that there were some problems and errors you did not want to correct. This is the difference. The question, very important and crucial question of today, the question of today. Who is running this country? I'll answer you. This country is run by the Prime Minister of Georgia, whose name is Irakli Porchkhidze. I will not name all the ministers, you should know the names on your own. This country is also run by one member of our team, who is the President, Giorgi, and I would not diminish, and as one of the participants here tried to do, diminish the importance of the presidential election last year, because this was the first presidential election after our country's independence, where the government, our government, and myself as a chair of the Interagency Council for Free and Fair Election, we did everything to have the most democratic presidential election in this country. The president, the then president, Saakashvili, stolen, and you should remember that in 2008 he stolen the second tour from Georgian people. There should be organized a second tour of the election, because he was not the winner during the first tour. He would refuse that. So this time we had an exemplary democratic presidential election which resulted in the election of Mr. Margvelashvili, and he's running the country with the Prime Minister of Georgia, whose name is Irakli Porchkhidze. I'm very sorry you didn't know this, and thank you for coming to know this too.
I feel like we focused too much time on one particular issue without discussing the context of state building. When the previous government came, what were their challenges, how they improved the system, and not talking specifically about human rights maybe, but also about putting systems in place, like dealing with backlog of cases, by adopting plea bargaining legislation, by fighting corruption, by making certain changes in the legislation, by adopting criminal procedure code. Your government also made very useful steps in changing the legislation to make it more transparent process of negotiating pleas, etc. So all of these changes are very important, and I thought that they should have been discussed more broadly. But what I wanted to say in my final comments was to maybe give a credit to both the previous government and the new administration, because it is very easy to debate these issues, to opine very elaboratively about this, but it takes a lot of courage to actually run for office and to face these challenges yourself and trying to improve these challenges yourself. So in my final comments, I just wanted to just bring the polarized discussion more concentrated to the outlook to the future.
Thank you, Nata. Giorgi?
Thank you. No, I thought that what I was trying to do in my presentation is actually to look at the state building project and how the shortcuts that were taken on the premises of building a strong state actually were weakening the state, because inability to prosecute and inability of accountability. Unfortunately, again, I think this is as it was stressed here repeatedly, this is the remaining problem, and I would see the questions and answer the questions within this framework. I think, again, I'm grateful, and because my minister is a human rights lawyer, she understands the absolute right of being free from torture, and how a person who is investigated, who has committed such a crime, how this is an absolute right, and there should be an investigation, and actually before any plea bargain or before any mitigating circumstances, there should have been full study of the extent to one's participation in torture because of such a gruesome crime. Obviously, again, this was done to achieve a goal, political or justice or whatever the goal was achieved. That was, I think this is a shortcut to achieving that goal, which is not making a strength, it's not strengthening the state, it's actually weakens it because of the shortcut that the government was willing to take and took. Whether this was why the Prosecutor General was sacrificed or not, this is different, but he was the Prosecutor General for time afterwards. As for the current challenges, let me leave it for the last, but I think political motivated cases, I think the biggest problem that I had with those cases was that I saw the sign of selective justice. And let me explain why I saw it. And Madam Minister here mentioned that there were tens of thousands of cases received by the prosecutor's office. And it's unfortunate, and I'm very glad to hear that it's something that the prosecutor's office now is studying and is about to finish it, analysis of those cases. However, without actually having a very clear criteria why those handful of cases were prosecuted, it seemed that the prosecutor's office were selecting, and this was a selective justice without knowing the exact criteria why they went after certain individuals and not after another. So I think this is something that is very good and positive, that the government finally evaluates the cases they received and actually tries to systematize and respond systematically and explain the explain their actions. As for the politically motivated prosecutions, when it comes to it, I think the methodology is for me is very clear. Unless the charges itself are political, which is very hard to prove, the key test is the due process rights and the judicial, the fair and trial. And that's something that there is a very big GYLA and several domestic NGOs are doing the observation of the trials, and this is open, this is public. I think that's a luxury that we did not used to have in the past, and I think it's something to be maintained moving forward. And until the trials are over, obviously, it's early yet to conclude the motivations behind those charges. As for the former Minister of Justice sitting here would be, no. Well, yeah, I mean, that was a problem, and he's not the Minister of Justice currently, and he paid the political price for it. If there is to be paid, other price for it, which is the prosecution, it should be in a transparent way, and something, if somebody is accused of such atrocities that you have mentioned here, such gruesome violation of rights, I think there should be an investigation of it, and done not by the Minister of Justice but by the prosecutor's office. It's a bit important, and you do mention the politicization of justice as important. Yeah. As for the remaining problem, there's a lot, and I won't enumerate all of them, but absolutely agree that accountability for law enforcement is, I think, the number one problem, and the cases are one too many or way too many, and that's something that should, I'm glad to hear that there is an intention to create an independent body and effective body for that. However, it obviously does not mean that the crimes committed now, last week, for example, a person was beaten in a police station. It has to be investigated now rather than wait for the mechanism to be in place. Unfortunately, again, and this investigation, at least so far, has not been effective. I think justice reform is absolutely crucial, and it's great, but without the substantial reform of prosecutor's office, which is still a problem in this country, I think they should go hand in hand if the justice system is to be to the standards. And I think one other problem that is still remaining, and is the administrative justice and the way it is implemented in this country. I'm very glad to hear to see that there has not been the administrative imprisonment used by the new government since 2012. However, the very fact that there has been used fines. So no matter what actually the punishment was used, it's extremely important that the due process rights should be in any administrative cases. Unfortunately, this is still not the case. I also have to note here that there is an initiative in the parliament to lower up from 90 to 15 days the administrative imprisonment. However, again, it's not about the days.
Also to introduce procedural safeguards, you should mention.
Which again, I have my opinions about it. But anyway, I think it's extremely important that the system is still in place, and it's a current problem, as well as I think violence against women. And you partly touched this problem. I think it's still a remaining human rights problem in the country.
Briefly, Kakha and Irakli.
Try not to test too much the patience of audience. I know that a lot of people are living, just to go back to the restoration of justice. I think that term is a political construct, with all due respect. And I think that just to have a kind advice, don't go too far with the restoration of justice, because there is no such a thing as to, you cannot restore justice for everyone. There is no standard of restoring justice. And the way that it is instrumentalized through the political channels and through the political establishment, I think that it's going to be a haunting experience. Just a kind advice. When it comes to the prisons, sorry, just to go back to the demands from the public. I was just recently looking at the polling and the survey of the NDI, which is a very recent one. It was actually published about a week ago. The demand of the public at the moment are jobs, social packages, the welfare, as well as territorial integrity. So just giving you a sense that the reality, I think, is much more complicated than that. I think it's a forward-looking agenda, even though that we're talking about the restoration of justice being the very core of what you have been elected for. But also, I think it's not the right language in a democracy, in any type of democracy, if we're talking to say that all the senior or all the officials of the previous government should put, sorry, but that's not the language you use. When we talk about when we are in democracies. The other thing that I think is extremely important is that when we talk about the eradication of opposition, I was deliberately not very precise about it when I was talking previously, but the comments that you made were actually made after the elections, so it was not made before, as you said. So when you were talking about the elimination of the opposition or the UNM, that was actually the post-election comment. And to go further, PM, Mr. Garibashvili, actually made that comment right before the local elections. He said that all the remnants of opposition party, which is UNM, should be taken out or cleansed. So I think that we have to be, we talk about politics here, and I think that the rhetoric of politicians, especially the ones who are in charge of justice and the ones who have a higher, I would say, higher degree responsibility towards the public, because we create cultural norms, the norms that will be defining political culture. So I think it's extremely important to have that in mind. Just to go further, I think with all due respect to your statement that nowadays government is run by Mr. Garibashvili and by I'm not even talking about the president, sorry for saying that, because he's stripped of all necessary powers to be an effective leader this time on. I have to be very clear that, the perception in the public, I'm not even saying about my perception, the perception in the public, which was actually once again very well reflected in the NDI polls, where 56% of Georgians are saying that Mr. former PM Ivanishvili has the influence on the decisions of the present government. So these are not my words, these are the survey results. So once again, I didn't want to be very, precise about things, but I think to set the record straight, I think it's extremely important to be very fair to the process itself. Thank you, and thanks, Erik, for the panel.
And Kakha, briefly?
Okay, I'll try to tell a few words briefly. I want to answer Otter on his question about our opinion about large-scale prosecution of former high officials. I think that only the fact that concrete former high official is charged is not enough to substantiate that there's politically motivated investigation or something like that. Every time you mentioned our past researches in 2012 and 2011. In that time, my colleagues, during several weeks, several months, we are studying all case materials, including court decisions, and finally we said that this concrete person was allegedly political prisoner or not. We have the same approach in this reality too. And only the fact that 100 or more former high officials are charged for us is not enough, and even is not a legal argument to substantiate that there's a politically motivated investigation. We made many critical statements about this investigation, and it is easily seen by our website and by Google search, and every interested person can this possibility to see what GYLA is doing in this regard. But about our opinion about the court decision with your client, I mean former president. GYLA 3 weeks ago, after the decision of first instance court, when the court said that when the court imprisoned pre-trial imprisonment of former president, we said that first of all, my colleague, criminal lawyer, was attending the whole process. Then we studied in detail the court decision, and finally we said that the position of prosecution was substantiated and the court decision was substantiated. And for us, only the fact that not ordinary citizen, but the president was charged in that case is not enough, as I told you, to conclude that there was politically motivation. We, with other high officials, GYLA, and some others, we have on their investigation some critical statements, but generally, I think the approach that when high officials are charged, it means the politically motivated investigation. It is not proper approach, and it is not legal approach to the case. I understand your position. You are a defense lawyer, and the code of ethics of lawyer in Georgia obliges you to try your best to defend your client's right. It's your obligation under our code of ethics of lawyers. But for me, as the representative of Georgian Young Lawyers Association, we does not matter who is the defendant. We are trying to, without concrete names, we are trying to be objective in any case. And yes, I agree with you that sometimes in investigation there are serious problems. And one main problem for me is that from that several thousand applications submitted in prosecution office, the problem is that the prosecution office does not have clear criteria what is its own strategy, what kind of crimes are under their priority to investigate at first time, and what is their plan to those several thousand applications. Sometimes it's fact when concrete application which is about less grave crime is investigated, and concrete other application which is about most grave crime is not investigated. This is selectiveness, and we of course are against this approach. But generally speaking, I don't think that all those charges against former high officials are politically motivated. After 1 month, we are going to have our new report about election and criminal justice. Probably this will be the title of this report, and there we will speak about the shortcomings of investigation in some cases, and I will invite you, and you will see our position on those cases. So if you want more detailed answer of our position on any concrete high official, including former president, I am ready for debate, for speaking here or any other place, anytime. Thank you.
I'm going to make a seriously nonpartisan statement here. I've worked on transitional issues across 30-some countries, and every society that goes through a transition as rapid as Georgia has gone through there are a host of legal issues and potential legal issues that arise. And how each society chooses the mechanisms through which to achieve the future varies radically. The institutional arrangements are extraordinary. And there are also choices to be made about the cases that are the most important to get to the future. Georgia is definitely in that process now, and we saw very different views about how that transition should be managed. But ultimately, you know, what is seen to be just is going to count for a lot in whatever is happening here, and choices are being made across the political spectrum. And you know, the perceptions of legitimacy of those processes will be very important, and that's going to be sort of a historical judgment in the future. With that, I thank all of the participants, and thank you all, audience.
So it's my duty to close the conference. This is the last public session. We've had a really great 2 days as far as I'm concerned. From the standpoint of, I think, my colleagues at CDDRL, this conference has exceeded our expectations in terms of teaching us about Georgia and its state building project. I'd like to thank this panel. Each one has gotten more and more interesting as we've gone along. I'd like to thank the EPRC, and where's Nino? Yeah. Nino, and then again, all of the sponsors that you see there on the board that made this possible. The fellows, the Stanford fellows, are going to have a private session tomorrow to talk about our network and how we go forward. But I think, you know, having this discussion of how Georgia goes forward in the future has been a real privilege. So thanks to all of you.